If you are 60 or older, and a police officer ever tells you to step out of your car, what you do in the next 30 seconds can either protect everything you have built over a lifetime or silently hand it away. Not because you did anything wrong, but because the law moves fast. Officers are trained to move faster, and most seniors have never been told what the law actually requires of them in that moment. This video is going to change that. After reviewing constitutional law governing police encounters and studying cases involving older Americans at traffic stops across the country, I have identified the 5 things every senior must do the instant an officer asks or orders them out of the vehicle. These are not tips. These are legally grounded steps that protect your 4th, 5th, and 6th Amendment rights in real time, on camera, before anything else happens. If you found this channel for the first time, subscribe right now. Every week we publish videos dedicated entirely to helping seniors understand their legal rights and exactly how to use them in the real world. Hit that subscribe button and stay with me, because step 3 is the one most seniors never see coming, and it may be the most important of all. This is educational content only. For guidance specific to your situation, please consult a licensed attorney in your jurisdiction. The first thing you must do before you touch that door handle is confirm whether the officer is asking you or ordering you to exit the vehicle. This distinction sounds simple. In practice, it is the difference between a voluntary act and a compelled one, and courts treat those two things in entirely different ways. When an officer leans into your window and says something like, "Do you mind stepping out?" or "Can you get out for a moment?" they are not giving a command. They are making a request. And under Pennsylvania v. Mims, decided by the Supreme Court in 1977, an officer may lawfully order a driver out of a vehicle that has been properly stopped. But that authority attaches to an order, not a request. When you comply with a request without asking which it is, your exit is captured on body camera as entirely voluntary. Courts have used that footage repeatedly to treat everything that follows as the product of a willing, cooperative driver. So before you reach for the door, you say this clearly and calmly: "Officer, are you asking me to step out, or are you ordering me to step out?" That question does something essential. It forces the officer to state their actual legal authority on the record, on their body camera, and yours if you have one running. If they say it is a request, you may decline respectfully. If they say it is an order, you now understand exactly where you stand legally, and you can proceed from that position with full clarity rather than confusion. Here is what it looks like when it goes wrong. The officer says, "Do you mind stepping out?" The senior opens the door and steps out without a word. The footage shows what appears to be a fully consenting driver cooperating freely, and that impression becomes the legal foundation for everything that follows. Here is what it looks like when it goes right. The officer says, "Do you mind stepping out?" The senior replies, "Officer, are you asking me or ordering me to exit the vehicle?" If the officer confirms it is a request, the senior politely declines. If the officer confirms it is an order, the senior follows up. And for the record, what is the lawful basis for that order? The officer must now either invoke officer safety under Mims or acknowledge they have no established basis. Either way, it is documented. Practice this phrase until it becomes automatic. "Officer, are you asking me or ordering me to step out?" "Officer, are you asking me or ordering me to step out?" "Officer, are you asking me or ordering me to step out?" The foundation of this step is straightforward. You must know whether you face a request or an order before you move an inch. That single question reshapes the entire legal character of the stop. The second thing you must do is verbally invoke your constitutional rights before that door opens. Most seniors assume that staying quiet is enough. The Supreme Court has ruled otherwise, and those rulings apply directly to what happens at a traffic stop. In Salinas v. Texas, decided in 2013, the court held that when someone stays silent during non-custodial questioning without explicitly invoking the Fifth Amendment, that silence can be introduced in court as evidence of guilt. In Burgess v. Tompkins from 2010, a person said almost nothing through hours of questioning, and was later found to have waived his rights because he never clearly stated he was invoking them. The combined legal rule is this: you must speak in order to protect your right to remain silent. Passive silence is not a legal shield. In the wrong courtroom, it becomes a weapon used against you. Before you open that door, these are the words that must be on the record. Officer, I am invoking my Fifth Amendment right to remain silent. I do not consent to any searches of my person, my vehicle, or my belongings. And I am requesting to speak with an attorney before answering any questions. 3 sentences. Roughly 15 seconds. Your legal foundation established and documented before your foot leaves the car. Each sentence carries its own constitutional weight. The Fifth Amendment invocation directly satisfies the requirements of Salinas and Burgess. The non-consent declaration protects you under the Fourth Amendment, because courts assess consent based on the totality of circumstances, and passive compliance during a stop has been treated as implied consent far more often than most people realize. Requesting an attorney creates a documented record of your Sixth Amendment awareness and protects you if the encounter escalates beyond a routine stop. Here is the wrong way. The officer orders the senior out. The senior steps out quietly. The officer asks how much they had to drink tonight. The senior answers. One honest answer opens the door to another question, and within 2 minutes, a routine traffic stop has become something far more serious. Here is the right way. Before the door opens, the senior states clearly, I invoke my Fifth Amendment right to remain silent. I do not consent to any searches. I am requesting an attorney. The senior then steps out and remains quiet. Repeat this 3 times. I invoke my Fifth Amendment right to remain silent. I invoke my Fifth Amendment right to remain silent. I invoke my Fifth Amendment right to remain silent. Silence without explicit invocation is not constitutional protection. The law requires the words. Say them before you open the door. You have now protected your right to silence and your right against unreasonable searches. But here is the gap in almost every piece of legal content aimed at seniors, and it is the step that matters more than most people realize. The physical act of exiting the vehicle can itself be interpreted as voluntary cooperation unless you say one more thing before your hand touches the handle. The third thing you must do is verbally announce your compliance under protest before stepping out. This takes 3 seconds. Before your hand reaches the door, say this: I am complying with your order under protest, and my hands will remain visible at all times. That single sentence accomplishes 3 things simultaneously. First, it establishes on the record that your exit is compelled, not chosen. Voluntariness is the central question courts use to evaluate everything that happens after you leave the vehicle. Documenting your exit as compelled, in your own words, removes the argument that you were freely cooperating with anything beyond the legal minimum. Second, the phrase under protest is a recognized legal signal. Any court reviewing the footage will understand exactly what it means. It communicates that you participated only to the extent the law required and no further. Third, announcing that your hands will remain visible neutralizes any later claim of furtive or suspicious movement, which officers sometimes use to justify a pat-down or frisk. Without that verbal declaration, the body camera footage shows a door opening, feet hitting the pavement, and a person walking out. It reads as cooperative. With your declaration on the record, the footage now documents a person exiting under legal compulsion, under protest, with hands plainly visible throughout. That is evidence your attorney can use at a suppression hearing to challenge the legality of anything that happened after you stepped out. There is one more detail here that almost no legal content for seniors ever mentions. Close the door when you exit. When seniors step out and leave the car door open, they dramatically expand what officers can observe under the plain view doctrine established in Horton v. California in 1990. Officers can now see your interior from entirely new angles. Any object visible from where they are lawfully standing can be noted and potentially seized without a warrant. Closing that door behind you limits your exposure and forces any further observation of the vehicle's interior to require a separate legal basis. Say this 3 times. I am complying under protest and my hands will remain visible. I am complying under protest and my hands will remain visible. I am complying under protest and my hands will remain visible. Document your exit as compelled. State your protest. Close the door. Those 3 actions together eliminate the ambiguity that silence creates. You have now protected the exit and minimized visual exposure to your vehicle. But the moment you are standing on that roadside, an entirely different set of legal pressures begins. Officers are trained to use that environment, and the questions that follow are designed to sound casual and conversational while building a legal record. The Supreme Court addressed your rights in this situation in Arizona v. Johnson in 2009, and what the court held connects directly to what you must and must not do next. The 4th thing you must do is stop answering questions the moment you step outside the vehicle. Standing roadside under flashing lights with cameras running from multiple angles, silence can feel like guilt. It is not. Seniors in particular tend to want to be cooperative and polite, and those are admirable instincts. But there is an important distinction between respecting an officer and building a case against yourself. Every casual question an officer asks outside that vehicle, where are you coming from? Where are you headed? Have you had anything to drink tonight? Is an opportunity for information to be gathered and used. Under Rodriguez v. United States from 2015, once an officer has completed the tasks directly tied to the reason for the stop, checking your license, registration, and insurance, and resolving the question of a citation, the legal justification for detaining you further expires. Any questioning beyond that point must be supported by independent reasonable suspicion. Every answer you give outside that car gives officers material to build exactly that. Here is how an ordinary stop escalates. The officer asks where you are coming from. You mention dinner. The officer asks whether you had anything to drink. You say just 1 glass of wine. That stop has now shifted into a DUI investigation built entirely from your own words. The officer asks if there is anything in the car you should not have. You say no. The officer says you would not mind if they took a look then. You are now standing at the entrance to a consent search, and the body camera has recorded every exchange that led you there. You already invoked your Fifth Amendment right to silence before you stepped out. Every question after that receives the same calm, respectful, consistent response. I have invoked my right to remain silent. No attitude. No frustration. No raised voice. Calm, firm, and polite throughout the entire encounter. When you believe the purpose of the stop has been completed, you ask this question plainly. Has the purpose of this stop been completed? Am I free to go? Under Rodriguez, asking that on camera forces the officer to either release you or state a new legal basis for continuing to detain you. If they have no basis, that is now on the record. Say this 3 times. Am I free to go? Am I free to go? Am I free to go? Every word you speak outside the vehicle is potential evidence. Your pre-exit invocation protects you, but only if you follow it by actually remaining silent. Do not answer. Do not explain. Stay quiet and stay protected. Before we reach the 5th step, there is one legal reality every senior must understand clearly before they are ever in this situation. Officers are legally permitted to lie to you during a traffic stop. They may claim to have evidence they do not have. They may say a witness identified you when none exists. They may tell you that cooperating will make things easier, when legally your cooperation changes nothing about their authority or yours. This is not a generalization about all officers. It is a documented legal fact about the boundaries of interrogation tactics under the law. Your invocation is not about having something to hide. It is about the straightforward reality that you cannot know what an officer believes, what they claim, or how they will characterize anything you say. After invoking your rights, saying nothing further is the only position that fully protects you. The fifth thing you must do is execute all of this in the correct sequence during the first 30 seconds of the stop, before you ever open the door. The first 30 seconds of a traffic stop establish the legal foundation that everything else rests on. Here is the exact sequence for seniors, and it applies regardless of your state. Pull over safely, and use your turn signal while doing so. If it is dark, turn on your dome light. Turn off the engine. Place both hands on the steering wheel where they are clearly visible. Roll your window down 2 to 4 inches only. Do not reach for your documents before being asked. Do not open the door before you have determined whether you are facing a request or an order. When asked for your license and registration, announce every movement before you make it. I am reaching toward the glove box for my registration. My hands will remain visible throughout. Then, before the door opens, speak your 3 sentences in order. First, I invoke my Fifth Amendment right to remain silent, and I do not consent to any searches of my person, my vehicle, or my belongings. Second, officer, are you ordering me to exit the vehicle, and if so, what is the lawful basis for that order? Third, I am complying with your order under protest, and my hands will remain visible at all times. Then step out. Close the door behind you. Stay quiet. And when the moment is right, ask clearly and calmly, "Am I free to go?" Your 4 core phrases one final time. Am I free to go? Ask this when you believe the stop has served its stated purpose. The answer tells you your exact legal position. I invoke my Fifth Amendment right to remain silent. Say it explicitly, out loud, before the door opens. The Supreme Court requires the words. Silence without them is not enough. I do not consent to any searches. State this clearly, and make sure it covers your person, your vehicle, and all belongings inside it. I want an attorney. Say it before questioning begins, before any arrest is made, and keep saying it if you are not immediately acknowledged. 2 state-specific notes. Because the law is not identical across every jurisdiction, and knowing the difference matters. In stop and identify states, which include Texas, Nevada, and Colorado, you are legally required to provide your name when you have been lawfully detained. Refusing can result in a separate obstruction charge. Giving your name in those states is a legal requirement, not a waiver of your other rights. In non-stop and identify states, such as California and Oregon, you have broader protection and may decline to identify yourself without creating an additional legal problem. On the question of marijuana odor as probable cause, in Colorado and Maryland, courts have significantly restricted the use of marijuana smell alone as a basis for searching a vehicle. In Texas and across much of the Southeast, the odor of marijuana still provides probable cause for a full vehicle search under current case law. Know the rules specific to your state before you are ever in this situation. This is educational analysis, not legal advice for your individual circumstances. Always consult a qualified attorney licensed in your state. Here is the principle that holds all 5 of these steps together. The 30 seconds before your foot touches the pavement are the most legally consequential 30 seconds of the entire encounter. As a senior, you have spent decades contributing to this country, raising families, building lives, and paying into the very system that is supposed to protect you. You deserve to know exactly how that system works in the moments it matters most. Speak your rights into the record before you open that door. Do it calmly. Do it clearly. And do it every single time. Your 4 phrases one final time. Am I free to go? I invoke my Fifth Amendment right to remain silent. I do not consent to any searches. I want an attorney. If this video gave you something you needed to hear, please subscribe to this channel right now. Every week we publish new videos specifically for seniors covering your rights during traffic stops, searches, detentions, and encounters with law enforcement of every kind. This channel exists because you deserve to walk into every situation knowing exactly where the law stands and exactly how to use it. Hit that subscribe button below, share this video with every senior in your life who needs to see it, and we will see you in the next one. Stay safe, stay informed, and stay protected.